The applicants also sought for pending the hearing and determination of the petition an order of injunction restraining the respondents or any other person acting under the instructions from interfering with the rights of education, health, housing of the children living within the Masai Mau complex through any form of eviction. Further, they sought for temporary mandatory injunction to compel the 5th, 7th, and 10th respondents or those are responsible to reinstate teachers and other educational administrators to schools where the children were undertaking instructions. The applicants also sought for pending the hearing and determination of the petition that the 6th and the 10th respondents be compelled to set up temporary health facilities, deploy health workers, and ensure provision of health services to the children in the affected areas. They also sought that pending the hearing and determination of the application, pending the hearing and the determination of the petition, the 12th respondent be compelled to issue birth certificates to children born and raised within the affected areas. Those being the orders which were sought in the application, these prayers were based on the grounds that sometimes between the year 2005 to 2018, the government had undertaken various evictions of residents in the area comprising of the former group ranches, discriminately and without any notice, right or legal justification to do so, and this in utter disregard of the proprietary rights, human dignity, and without due regard to the constitutionally guaranteed rights of those residents. The applicants further allege that the evictions aforementioned were conducted at night and in bad weather, and the families brutally subjected to torture. And now, through the utterances of the Cabinet Secretary, Minister of Environment and Natural Resources, as well as the Regional Commissioner Rift Valley, they threatened to carry out phase 2 of the evictions in the same area, which eviction will amount to illegal and unlawful, and thus compound the precarious situation of the children in the concerned areas. The applicants further contended that if the evictions commence, over 60,000 families will be forcefully displaced, resulting in a humanitarian crisis, leading to the displacement of children, affecting the constitutional rights and freedoms, and especially those sitting their national examinations, which will begin on the 29th of October 2019. And under Section 13 of the Environment and Land Court Act. In the instant application, the applicants have sought the intervention of this court in safeguarding the fundamental rights and freedoms of the children within the Masai Mau complex. And in view of these orders which are being sought, the question that ought to be answered is whether the Environment and Land Court has jurisdiction to hear and determine the same. In the case of owners of motor vessel Lilian S. vs. Caltex Oil Kenya Limited, Justice Nyarangi, as he then was, expressed himself in the following terms when he addressed the issue of jurisdiction, and I quote, "Jurisdiction is everything. Without it, a court has no powers to make one more step. Where a court has no jurisdiction, there is no basis for the continuation of the proceedings. A court of law downs its tools in respect of a matter before it when it holds that it has no jurisdiction," end of quote. In the case of Joseph Njuguna Maura and others versus the Republic, Criminal Appeal number 5 of 2008, the court also held as follows, and I quote, "It's incumbent upon any court intending to render an opinion or determine a matter to first ascertain the entry point to the doors of justice, and that entry point is jurisdiction," end of quote. The applicants had in their submission stated that the court has a right the right to hear and determine the instant application and the substantive petition under the provisions of section 13(2) of the Environment and Land Court Act. However, I respectfully beg to differ with the said submissions to the extent that the instant application in the petition in its entirety seeks the enforcement of rights to education, right to health, right to prenatal and postnatal health, right to health centers, right to birth certificates, and other documents of civil registration as clearly outlined in the phase of the application, and more particularly prayers A, B, C, D, and E, which in my considered opinion do not fall within the jurisdiction of the Land and Environment Court. Having determined that I have no jurisdiction to hear and determine the application before me, I have no other option but to down my tools accordingly. The upshot of the above is that this court lacks jurisdiction to hear and determine the petition and the instant application. I therefore order that the same be struck out. Since this was a matter of public interest litigation, I direct that each party shall bear their own costs. Orders accordingly. Basically, that was a bit too technical maybe for the members of the public. You simply tell them that this was an application that was seeking for the enforcement, the rights and enforcement of children living within the Mau complex. And that is a case that is best handled by the High Court, either the Constitutional and Human Rights Division, and not the Environment and Land Court. So in view of that, I find out that I've concluded that I have no jurisdiction to entertain the petition and the application, and therefore strike it out.
The court has made its ruling and delivered its ruling, which on behalf of the Friends of Masai Mau Complex, an interested party in these proceedings, we welcome, we thank the court for not stopping the evictions in the Mau Forest. Mau Forest is a very important forest in our country and beyond. It serves not just the people within Narok County, but even beyond the boundaries of this country. And therefore, the court has made a determination that it has no jurisdiction to entertain the current application as brought before the court, because it basically talked about education right, the right to health, the right to education, and other matters that this court does not have jurisdiction to determine on. But most importantly, we have argued that in our submissions and in court, that the current application and petition before the court is a cosmetic facelift of the petitions that are pending before a three-judge bench in Nakuru. That is petition number 12 and 13 of 2018. That is the argument of the Friends of Mau Forest, which I represent, and therefore by the petitioners purporting to bring the issue of the right to education and children's issues was just a cosmetic facelift on the applications before the Constitutional Court. And we are happy that the court has declined the orders that are being sought by the petitioners in this case. The petitioners in this particular petition, number 12 of 2019, are the same petitioners in petition number 12 and number 13 of 2018. And therefore, they are engaging in forum shopping, an abuse of the court process, and we want to thank the court for not stopping the evictions in the Masai Mau. We welcome the ruling, and we are urging the persons who are at the moment tasked to preserve the Masai Mau to continue preserving, because we as the Friends of Masai Mau Complex have a huge interest in the conservation of Masai Mara. And therefore, we are very happy. This is a very important day and a happy day, not just for the persons living downstream or around the Masai complex, but even for the crocodiles and the hippos and the animals in the Masai Mara, which are crying for justice. And they had no anywhere else to go to but to come to court, and their voices have been heard. And we just want to thank the court for hearing also the cries of the crocodiles, the cries of the wild beasts, the cries of the hippos and other animals that are dependent on the Masai Mara complex. Thank you. Of the Friends of Masai Mara, when we were arguing this application, that the application itself was incurably defective, in the sense that the purported petitioners who purportedly brought this petition on behalf of the minors or children within the Masai Mara did not give a name of any minor who is affected by the ongoing evictions. And therefore, and they did not also give a registration certificate or title deeds on which those schools are built. And therefore, our view is that there are no schools recognized by the Ministry of Education within the Masai Mara complex. And if there are any, those are just structures, but not education centers as recognized within the Education Act or within the Ministry of Education.